Listen, this is my life.
I understand that, sir, but you're asking me questions I can't.
27 days incarcerated for no reason.
No, there is a reason. You pay your child support. Now, if you want to keep going, I can do something else with the bond. But I think we're done here. Thank you.
This is my life, man.
Yes, I know. And you take part of mine that I will get back. Goodbye. Goodbye. Calls case versus Larry Matthews. Madam Attorney General, if you could state your name, please.
Oh, sorry, Judge. Carrie Angie for the people.
Thank you.
And Assistant President Nick Bukovich for Mr. Matthews.
All right. Your name, sir?
Larry Matthews.
All right. What are we doing?
Mr. Matthews indicated he'd like to speak to you, Your Honor. I did advise him against this. However, he would like to speak to you at this time.
Speak to me?
Yes, Your Honor.
For what purpose? What do you want to say?
I have evidence in my case. I wrote a letter also and submitted information into my case.
That, but what do you want me to do with that?
Well, this case is for year 2010 through 2013 for a total of $58,000 in child support. So for those 3 years, it's calculated up to $1,100 a month. At that time, I was on food stamps, and that, that amount would not have been an accurate child support amount. Now, as far as the warrant, I went to court in Tennessee in September 9th of 2021 on this matter, and a judge ruled on it. So I wasn't aware of a warrant or anything like that. I've sent certified mail.
Told all of this to your attorney because you're telling me, but I can't do anything.
I have. My attorney refused to work for me as I needed him to.
Oh, so with your law degree, you were going to try to tell him what he needed to do, and
It was
some of that stuff he couldn't do. So he's not working for you.
Forgive me, Your Honor, for addressing the court, but it's not submitted any information that would get me home to my family. I have my employer has advanced me $10,000 towards my bond, get home to attend to my business on Monday.
I did send information that was provided to Ms. Gaines by Mr. Matthews' rights to A.G. Williams this morning. Obviously, A.G. Williams is not the on today, but that was the attorney on the docket, so that's who I sent this information to and communicated with earlier this week about Mr. Matthews.
So you actually did your job, right, Mr. Bukovich? But nobody appreciates it. I got you. Anything else you want to tell me?
Yes, sir. I was extradited from Texas. From here, it's been a total of 27 days that I've been incarcerated. The letter that I wrote to you explains a lot more in detail. I have $10,000 for my bond so that I can be released to get back to work. My wife
requires 25%. So if you're at 58, I'm going to be somewhere around 16, 17,000.
14,500.
I have your bond in this case set at 16,80462.
Yeah, the numbers that were submitted for the total is about 3 different numbers. And I'm not sure which one is correct. I received a letter in the mail.
Well, if you paid the 16,000, it's going to go to where support should be anyway. So I'm not changing the bond.
All right.
Anything else?
No, sir.
What do you want me to do with this case?
Yep.
I just opened that to the floor, I guess. I don't know.
You asking me? You asking me?
Huh? Whoever wants to answer me.
Well, I believe that the 10,000 should be accepted.
Okay.
Home to my wife and sons.
10,000. Then you need to come up with about 6,000 plus more.
This case is between the years of 2010 and 2013.
Okay. And somehow those children had to survive without you paying your child support.
It was only 3 years. My son is 30 years old now.
Okay, and it's owed.
and I want to pay it, sir. I do want to pay it. Can I start with the $10,000?
We will take the 10. Then you gotta come up with 6. I told you that. I mean, I'll keep repeating myself as long as you want to keep repeating yourself. I don't have a problem. I got all day.
I mean, you just send this form.
When is the court date?
He'll give it to you. Yeah, I can do it.
Spoken to him one. Whether he's still just.
What? We wait a little longer, he'll probably have 12,000.
What?
Yeah, as long as we go. Just a lot more money. I'm thinking.
This is the offer we talked about on Tuesday when we were in jail. We're waiving up. If you pay the certain portions down, they will reduce the charge.
To do that.
Wow.
Suspects is sure. We'll be waiving, Your Honor.
Pardon?
Be waiving, Your Honor.
Okay. Right. That is almost lunch. So you're waiving your right to a preliminary examination?
Yes,
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
yes,
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
when would the hearing be?
Pardon?
When would the hearing be?
Soon. I will set a date.
Okay,
I mean, this isn't a negotiation. You want to waive or not?
well, I
You
do,
want to waive or not?
I do, but I don't understand all the court proceedings because
Okay, and that's why
I'm not a criminal.
to listen to him.
He's been doing this for 2 years. And I'm not a criminal.
It's 2 years long. Do you wish to waive your preliminary examination?
Yes,
You will also waive?
Yes, Judge, thank you.
Thought everybody was. All right. Preliminary examination having been waived, defendant is bound over to circuit court on a single count. Mr. Bukovich, with your 2 years experience, can you do this part? Go ahead.
To waive formal reading information and stand mute as to the charges.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be set.
1:30, Judge Slay.
Here's your date, April 9th, 2026, 1:30 before Judge Slay.
well, I have one question, Your Honor. If I pay the bond to get out, I reside in Tennessee. That's where my home is. Will I be allowed to go home and then come back to court?
If you pay the bond,
So-
you're gonna have to stay in Michigan until the court gives you permission. So now, this having been waived, Judge Slay would be the one that you'd have to ask.
Well, where would I stay here in Michigan?
Where would you stay? Well, we're providing accommodations at this point.
Well, once I get out.
I don't make hotel reservations. I don't. Oh. Can't stay at Childers' house. This thing.
Listen, this is my life.
I understand that, sir, but you're asking me questions I can't.
27 days
with.
incarcerated for no reason.
No, there is a reason. You do pay your child support. Now, if you want to keep going, I can do something else with the bond. But I think we're done here. Thank you.
This is my life, man.
Yes, I know, and you've taken part of mine that I will get back. Goodbye. Goodbye.
Judge Simpson, if I could just say, and I think he may be too proud to say, Joy Gaines, Senior Assistant Public Defender, his wife contacted me, and either today or yesterday, I mean, their son was murdered within the past year, and this is the court period time. So I think he is under a level of stress. And
I understand.
so I just want to apologize.
It's a motion, a way to do that.
Yes, yes.
Just to listen to Mr. Vukovich.
Yes.
Mr. Vukovich could have gotten that before the court. It could have been addressed. He wanted to handle it his own way. So my condolences to his family, but this isn't the way it's done.
Yes.
Thank you.
Yes, sir.
Court calls the case, People versus Kylie Burton.
Good morning again, Your Honor. James Fifelski on behalf of Mr. Burton. Can you say your name, please?
Kylie Burton.
He said, I don't want to come up now. All right, what are we?
A hard act to follow, Judge. All discovery is in. We ask the court to set this for preliminary exam, please.
People have their witnesses available the 7th. Preliminary examination in person, April 7th, 2026, 9 a.m. before Judge Perry. Bond continued.
Thank you very much, Your Honor. Thank you.
Court calls the case of the People versus the Chardonnay Sanders.
Rob Dowd is prosecuting attorney of people on both cases.
Good afternoon, or good morning, Your Honor. Marcia Craig on behalf of Ms. Sanders.
What?
Good morning, Your Honor.
Oh,
I'm excited.
out there, you explored the world, thought the place was better than Washington County, and you're back.
Yeah, it was a long journey, Your Honor. But I'm glad to be back. I'm so happy to be back.
It's like Groundhog Day. It's just going to repeat itself.
Hi.
Well, it's good to have you back.
Thank you.
Your name, ma'am?
The Chardonnay Sanders.
Thank you. You need an adjournment.
Yes, please, Your Honor, to making sure I have all discovery and then to share that discovery with my client. Additionally, my client is.
The 9th work for you?
I'm sorry?
The 9th work for you?
Yes, it will, Your Honor.
Probable cause conference will be adjourned April 9th, 2026, 9 a.m. Bond.
Well, my client's asking me to make a bond modification argument, Your Honor.
Okay, go for it.
Okay, thank you. My client's currently charged with 2 cases that are very serious. She understands that, but those are allegations. She'd like me to relay to the court that she's lived in this county her entire life. She has some children that she needs to ensure that are being taken care of. During this time, she has been working on her case service plan for her neglect and abuse case, and she's doing well. She does not have a job at this time, so the bond amount that in each case is a financial hardship for her. She's willing to do a GPS tether. She understands that she needs to come back to court, and she has family in the area that she could stay with and support. So we're asking to lower the amount to a PR if possible and or a 10% component, Your Honor. Thank you.
Response from the people.
But I would ask the bond saying she failed to appear on the child abuse case and this court. Second charge, she got picked up and she was here before you was assault, great bodily harm, less murder. She allegedly stabbed her mother's girlfriend in the arm, causing a lot of damage.
My client tells me that she had her cell phone stolen from her, and that's why she missed her court date, Your Honor.
Okay. Thanks for letting us know. Given all those circumstances, I'm not going to reduce her bond. Her examination is coming up, and we can certainly address it at that point in time after the testimony is heard. Motion for bond reduction is denied.
Thank you, Your Honor. Thank you.
Court does.
Your Honor.
That's it for you?
That's it for.
Just pop in and now you're gone.
That's it.
You did that the last time. Court calls the case, People versus Timothy Peters. It's the AG case.
Morning, Honor. Rob J. Kill on behalf of Ms. Peters. Tiffany, would you state your name for the record?
Tiffany Comer.
Good morning, Judge. Carrie Angie on behalf of the Attorney General's Office.
Judge, we've had several PCCs in this matter. My client's, she's current in her child support. There's been an offer made. We want to resolve this matter and take it up to circuit court. So my client would like to waive up to circuit court. The problem I have is my client's in West Virginia. You being the kind
On
of
purpose?
considerate judge you are, I'll get a waiver in the file.
I love West Virginia.
You?
Well, I do, actually.
Good. Then
Don't understand how you get down some of those mountains, but that's all right.
my client knows the right she has to have an exam. I've spoken with her this morning. Again, I don't have a waiver form per se, but I will get that filed within a week.
Ma'am, you're waiving your right to a preliminary examination.
Yes, Your Honor.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
I do, yes.
And you understand that you'll not have that hearing. You'll proceed to circuit court for further resolution.
Understood. We get
And
up and
I
down
really-
the mountains
I
with
really do
Subarus.
like West Virginia. What'd you say?
We get up and down the mountain with Subarus.
But some of those roads are, well, anyway. All right. People also waive their right.
Yes, Judge. Thank you.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count. Mr. Killen.
Judge, we now just received this information. Wait, reading my client stand mute.
Defendant having waived formal reading, standing mute, court will enter not guilty. Pretrial will be set for
At 1:30 with Judge Liz.
May 18th, 2026, 1:30 for Judge Hammoud.
Thank you, Judge.
Thank you, Your Honor.
Bond will continue. Thank you, ma'am.
Thank you, Your Honor.
Is that it for you, Madam Attorney General?
That's it for me, Judge. This was a pleasure as always.
All right. Take care.
Likewise.
Court does call the case. People versus Anthony Turner.
Your Honor, ready for the people? Good morning, Your Honor. So we have Anthony here.
Gonna need 90.
Here's one bit.
Anthony Sherrod Turner.
Thank you.
Thank you, Your Honor. Based on some circumstances, I'd like to refer this matter for a competency exam.
Forensic evaluation is hereby ordered. A set of competency hearing June 25th, 2026, 9 a.m. Bond will continue. Thank you. Court calls case People versus Abdul. Abdul.
Good morning, Your Honor. Assistant Blood Defender Abdul Liba on behalf of Mr. Abdulatif.
Your name, sir?
Those Abdulatif.
Take your hands out of your. Okay, gotcha. All right, what are we doing?
And Your Honor, I'd like to please set this matter for preliminary examination.
Is discovery complete?
It is, Your Honor.
Do you have other witnesses available the 7th? Preliminary examination in person will be set April 7th, 2026, 9 a.m. for me.
Thank you.
Bond will continue. Court calls case People versus Jada Olive.
Your Honor, ready for people?
Here we
Yes.
go. Two.
One.
Good morning, Your Honor. Bill Clovis, P 38434. Thank you for allowing me to appear by Zoom. I'm in Wayne County Circuit Court. I was appointed by the Chief Judge to resolve several cases on a crash program facilitation. And so I'm heavy, but I can't be spread that thin to get to Ann Arbor.
All right. Very
And
good.
Judge, by the way, you know, you've heard of, well, of course, in the news, the Nobel Peace Prize. You get the Nobel Patience. After that one case, Patience Prize.
Well, thank you. Wait to
You
see
know,
that trophy.
But you can
Any
only
cash?
put somebody in jail so much. Anyway, I'd like to have another conference because I just recently got involved in the case, retained, and discovery if we could have, please, a probable cause conference in the future.
All right.
And Your Honor, Robert Ellman on behalf of Miss Olive in the other matter. Miss Olive, can you state your name, please?
Jada Olive.
And Your Honor, I know Miss Olive has retained another attorney for the other matter. However, I don't know if there was a mix-up if Mr. Kolovos knew she has two matters, so I'd be asking for an adjournment as well. I was just appointed yesterday to figure that out and see if Miss Olive will be moving forward with me in this matter.
Or with
retaining counsel.
All right. Will the 16th of April work, or did you need more time?
I'm sorry, go ahead.
I have a conflict on that date, Your Honor. I apologize.
23rd, we do any Thursday.
That works for me, Your Honor.
Motion the 23rd of April worked perfect for me, Judge.
Right, granted. Probable cause conference, April 23rd, 2026, 9 a.m. Bond will continue in these cases.
All right, you're the best, Judge. Thank you.
Thank you, sir.
Thank you, Your Honor.
What you think? Right there. Shoot wide. Court calls case, People versus Brandon Bogs.
Take candy for the people, Your Honor.
The public defender, Clemente, Your Honor, on behalf of Mr. Brandon Boggs.
Why are you looking out the door? You do that all the time. What?
Good morning.
Here, or are you just looking at the door hopefully?
He's here, Judge. Good morning, Your Honor. He was here this morning. There he is.
Oh, you stall long enough. Right.
Trying to state your name for the record.
Wearing a Bogs.
Set this matter for preliminary examination.
Discovery is complete.
To our knowledge, Judge, yes.
People have their witnesses available the 7th.
Sure.
Preliminary examination, April 7th, 2026, 9 a.m. before Judge Perry.
Okay, sounds good. Thank you so much, Your Honor.
Here. Bye. Bond will continue.
You make people nervous.
I make people nervous. Did I make you nervous? I used to, not anymore. I can go back. Okay. Court calls the case, People versus Walter Peterson.
And good morning, Your Honor. Robert Ellman with and on behalf of Mr. Peterson. I'm gonna open.
Have to get music for these intermissions.
I don't think you want me to sing, Your Honor.
I do not. Oh.
Hello.
Good morning, Mr. Peterson. Can you state your name for the record, please?
Walter K. Peterson.
Thank you.
Your Honor, I'm requesting one more adjournment of this PCC. We're trying to reach a resolution. I believe we're very close. There's just some final things I'd like to get some answers to before we move forward.
Sorry. April 9th,
That works for me, Your Honor.
2026, 9 a.m.
And Your Honor, if I could address bond briefly. I know Your Honor has allowed Mr. Peterson to be released to treatment. He would like to do that. Unfortunately, I know the order that we submitted with the people had a stipulation for a GPS tether on there. I'd be asking for him to be released without the tether. He does not have phone or any financial ability to get one right now.
That the only thing holding him up from going?
Yes, Your Honor, I believe that is the issue, is he would need to be placed on a tether, and I believe he needs a phone to be able to do that.
Have we received that communication from you? Don't have any jail indicating that.
I will follow up with the jail then and we'll clarify.
Send that and then I can consider it.
Thank you, Your Honor.
All right. Thank you.
Asking, can I address him? I can't just address him without it.
What do you have to say?
Sammy's trying to get up off of that stuff and reemerge back into trying to get me a job.
He knows that. We'll do that once we get you out to treatment. Okay. Thank you, Your Honor.
Ron, continue. Clerk calls the case. People versus Erica. Is it Clemente?
A repeat drunk driving offender faces the judge in this tense courtroom hearing. The judge makes it clear that reckless decisions behind the wheel can destroy lives. Before delivering the sentence, the judge issues a powerful warning about alcohol abuse and response.
Hello. What's your name?
Defendant Nicholas Buckovich has been Clemente.
Sorry to wake you up.
Sorry, Your Honor.
Your name, ma'am?
Erica Clemente.
I have before a plea form
That's correct, Your Honor.
that indicates that she's going to plead to the charge of use of methamphetamine, the 1-year offense. Upon her successful plea to that count 2, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
Is that correct?
Yes, Your Honor.
May I have her sworn?
Raise your right hand. Solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So
Yes, I do.
state your name, please.
Erica Clemente.
All right, ma'am, it is this court's understanding that you're going to plead to the charge of use of methamphetamine, a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. You understand that?
Yes, Your Honor.
Still wish to plead guilty?
Yes, I do.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
Signed an advice of rights form, is that correct?
Yes.
Question about any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor, I do.
Understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
I am.
All right. Were you on probation at the time of this offense?
No, I was not.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
Nope.
You're doing this voluntarily
Yes, I am.
and of your own free will,
Yes,
and because you believe that you're guilty of this offense?
I am.
On February 10th, 2025, at the location of East Clark Road near Prospect, Superior Township, Washtenaw County, State of Michigan, did you have fentanyl in your possession? Well, did you have methamphetamine in your possession?
Yes.
All right. Had you used it?
Yes.
You know what you were using was methamphetamine?
Yes.
Ma'am, I do have to apprise you that if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, the court would no longer be bound by any evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
I do.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No.
And have I complied with the court?
Yes, sir.
The defense is satisfied, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
April 21st at 10 a.m.
April 21st, 2026, 10 a.m.
Yes.
And Mr. Buckovich did a good job for you.
You did a great job.
See, that's what I'm saying.
Thank you, Your Honor.
I knew he would. Just some people don't appreciate it.
I will send you.
Tennessee, don't worry about it.
I have to vote today. Okay.
Thank you so much.
I'm happy to see that.
Court calls the case, People versus Darius Walkley.
Morning, Your Honor. Raymond Cook to the people. David I. Goldstein, appearing on behalf of the defendant.
Are we waiting? Because all I can hear is Cannon talking. Does what? No, it's not. It really isn't.
Various time.
Darius Walker. Thank you.
Your Honor, we're asking for an adjournment for two reasons. One is I have not yet received discovery in this matter. And second of all, I'm considering a referral, forensic referral.
Got it. And we set your other ones on the 16th or
9th.
no,
One was on the 2nd, one was on the 9th. So whichever the court prefers.
April 9th. It's 9 a.m. On continue. Thank you.
I'll deal with this. I'll have the case report. It is.
Court does call the case People versus Taj Smith.
And good morning, Your Honor. Robert Ellman on behalf of Ms. Smith, who should be present over Zoom. Wonderful. Ms. Smith, can you state your name for the record, please?
My bad. I couldn't get my camera on.
You got it. What's your name?
Taj Smith.
All right. I have before me a plea form that indicates that the defendant would be pleading to an added count 2 of receipt and concealment, 200 to 1,000 to 1 year offense. Upon her successful plea to that charge, count 1 would be dismissed. There's a sentence agreement to sentence under hiding. That's the court's full understanding of the agreement.
That's correct, Your Honor. Correct, Your Honor.
Ms. Smith, could you raise your hand, please?
Yes.
Your right hand? Is that your right hand? That's the other one. Yeah, there we go. All right. You promise to tell the whole truth and nothing but the truth, so help you God.
Yes.
All right. State your name again for the record, please.
Taj Smith.
You can put your hand down.
Okay.
All right, ma'am. This court's understanding. You are going to be pleading guilty to the charge of receipt and concealment of stolen property, 200 to 1,000.
Yes.
That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken if that's greater, or receipt and concealed. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes.
All right. And understanding all of that, you still wish to plead guilty
Yes.
to that charge? How do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form or had one signed on your behalf?
You said what?
Did you sign an advice of rights form or have one signed on your behalf?
Yes.
Do you have any questions regarding any of those rights?
No.
All right. You understand that you're giving up all of those rights, including the rights contained in paragraph 5.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily
Yes.
and of your own free will,
Yes.
and because you believe that you're guilty of this offense?
Yeah. Absolutely.
Pardon?
Yes.
January 6, 2025, at the location of 2785 Oak Valley Drive in Pittsfield Township, Washtenaw County, state of Michigan, did you come into possession of a Fender guitar?
Yes.
At the time that you came into possession of that, did you know that that property was stolen or had reason to know that it was stolen?
Yes.
All right. And would you agree, ma'am, that the value of that guitar was in excess of $200?
I don't know what that means.
Pardon?
What
You
does
don't know
that
what that
mean?
means? That guitar was worth more than $200.
Yes.
You right? Okay. And you're aware of that, right?
Yes.
All right. And you did not have anybody's permission, like the owner of that, to have possession of it.
No.
All right. Ma'am, I do have to advise you, between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from people?
No, Your Honor.
Have I complied with the court?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing will be
April 29th at 12 noon.
April 29th, 2026, 12 noon,
April 29th. Okay.
before me. Bond will continue. Thank you.
Thank you, Your Honor. Have a great rest of your day.
You
The
too.
same. Court calls the case, People versus Kimberly Douglas.
Okay, well, for people.
Can Assistant Public Defender, on behalf of Ms. Douglas, I know Ms. Douglas has some mobility issues, so it may take an extra minute for her. Good morning, Ms. Douglas. Can you please state your name for the record?
Kimberly Sue Douglas.
Thank you. You're asking for an adjournment.
Yeah, just to track out what's going on with her felony case is already in circuit court.
You're already,
Yes.
okay. When is the next?
He actually has a court date for those matters today, so I do not have the next date for that yet. So I can always file stip if needed to adjourn back what is going on.
All right.
I apologize for not having a date, Your Honor.
Oh, that's all right. April 16th, 2026, 9 a.m. Bond continued. All right, thank you, ma'am. Court calls case for the People versus Deborah Colette.
And Assistant Public Defender Nicholas Bukovich on behalf of Ms. Colette to be appearing via Zoom. I do see her name up there.
Okay, you'll need to unmute, Ms. Colette. I see you, but hello. State your name.
My name is Deborah Colette, Your Honor.
Thank you.
At this time, Your Honor, we'll be asking for a brief adjournment. I provided some documentation yesterday that APA chilled us to consider for a resolution in this matter, and Ms. Colette intends to provide me some more tomorrow.
April 16th, 2026, 9 a.m.
Thank you so much, Your Honor.
Bond continued. Thank you, Ms. Colette.
Thank you, Your Honor. Have a nice day.
You too. Court does call the case People versus Robert Jovasheski.
On behalf of the people, Your Honor.
Assistant Public Defender Chardonnay Sanders on behalf of Mr. Jovasheski.
Shesky. You don't know.
I don't.
Yeah. Your client. How come I know and you don't?
Bad with names.
Sir, keep looking ahead.
I'm sorry, Your Honor.
State your name.
Jovasheski Robert.
Now, we'd be asking for an adjournment today. We would be submitting a competency evaluation.
You're going to be requesting a forensic.
That's correct, Your Honor.
Probable cause conference will be adjourned April 9th, 2026 next. Bond continued.
We request that to be done in person, ma'am.
Say that.
Can we request that the competency exam be done in person and not over the video?
I can talk with them and see.
Would you please, because I can't hear and it presents a big issue and I don't want to be uncooperative.
Okay.
All right.
Did you want me just to order A, or did you,
I have the report.
or you have the, do you have the form?
I-
Because I can order it today if you
Perfect.
want.
Okay.
Okay.
Yep. I'll
I won't have to print it out. A forensic evaluation will be ordered. I'll set a competency hearing for June 25th, 2026, 9 a.m. We can move that date up if we get a report for then.
Okay.
Okay, Bob, we'll continue.
Your Honor, I apologize for my behavior to you, sir.
Not a problem. Take care of yourself. Keep moving, keep moving. Why do you do that? What?
In a shocking courtroom moment, prosecutors describe a terrifying crash that could have ended in tragedy. According to testimony, the passenger suddenly grabbed the steering wheel while the car was moving at nearly 65 miles per hour. Witnesses say the suspect shouted, "I'll kill us both," before forcing the vehicle straight into a concrete wall. The violent impact left the courtroom stunned as the details unfolded. Prosecutors argued the act was intentional and could easily have taken lives. After hearing the evidence, the judge didn't hesitate. In a firm ruling, the judge declared there was enough evidence to move forward, binding the defendant over on all 4 serious felony charges.
This courtroom hearing reveals a dangerous night that nearly turned deadly. Police testified that Andrew Lee White blew through a red light and ignored emergency lights as officers attempted a traffic stop. Instead of pulling over, the driver allegedly sped away, reaching nearly 100 miles per hour during the pursuit. When officers finally stopped the vehicle, signs of intoxication were immediately noticed. Prosecutors argued the reckless driving could have easily killed someone. In court, and the judge reviewed the evidence and the testimony from the officer. The decision was firm. The judge ruled there was enough probable cause and ordered the case bound over on multiple serious charges.